Hi, it's Chris Watkin here, and I'm joined by Mike Stratton, who is the boss man of tenantSERVE, who are an eviction specialist for tenants. Mike, thanks for joining me today. The question I would like to ask you is, talk to me about the eviction process post-COVID. Talk to me.
Well, thank you for inviting me today anyway.
Pleasure.
Really
Pleasure.
appreciate that.
Pleasure.
It's really was one of those times where COVID threw everything on its head. The courts shut, bailiffs stopped, and it was literally a closed shop, and nobody knew what was going to happen. We had the bailiff's going to take somebody out of a house on a Friday, cancelled. So post-COVID, it's slowly coming back to normal, and I mean slowly. The courts are using COVID as an excuse. They're restricting the number of people going into court for the hearings, and it's just slowed it up. And they really are looking for excuses to chuck a case out. Everything has to be absolutely right or it's out. So post-COVID, slow but progressing.
Okay, so what are the sort of excuses that courts are using that probably would have got under the radar pre-COVID?
Okay, the correct notice. So during COVID, you had to adhere to the notice, the revised notice that the government put out, and if you weren't aware of that, then it's out. Also, you have to make sure that everything's okay with the client over COVID, so that they're not suffering through that. You have to have evidence of that. If you haven't got that, it's out.
What does evidence look like?
It's a form saying, are you okay? Is everything right?
But they're not going to sign that at the bottom, are they?
They do, and the people that knew the system played the system. Believe you me, they took advice from various charity organisations, and they have put, and the same now as breathing space. That is being abused. That is one of those contentious items there that. Even Friday, just gone, another case there, the bailiffs have now been stopped on breathing space. They're all to do with the COVID regulations. And we all think that COVID's come and gone. Well, believe you me, in the courts it hasn't.
Well, we're filming this in late July 22, so it's been around a while, the breathing space legislation, hasn't it?
It's been around too long. It's an excuse. If someone is genuinely, if you genuinely are under there's something happening and you're trying to sort your bankruptcy out or your finance out, hey, good luck. But don't use that as an excuse. The majority of my cases on Section 8, the tenants are looking for every which way to wriggle out of it.
So is it the responsibility of the agents to ensure that the right forms are filled in? Anything else that agents could be doing?
Yes, it is. That it has to be the right form. It also means that it has to be in the right format, and it has to be presented on time. And so for agents, we do an awful lot of Section 8s. That's our main side. And it looks quite simple on paper, but it's not. Even down to the representation. So if you've done court before, brilliant. If you know the format and you can talk to the judge, but we put an advocate in. And an advocate runs that day. They run the hearing.
An advocate, posh word for a solicitor.
Yes.
Yes.
Posh word.
Yes. And do you think an awful lot of letting agents try and do it themselves? A lot of letting agents, they're perfectionists. They want to do everything right. I'm surprised they would want to go into the courtroom and, why do you think agents do that?
I think sometimes it's to do with control. They want to keep control of something. They want to keep it in-house, which is a natural thing to do in business. But there are so many mistakes that can be made. And to represent in court, yes, you need a professional.
I mean, I talk to some letting agents, and you can wave goodbye to a whole day if you're in court, can't you?
Yes, you can. And there's the cost side. Unless they're going to do it as a free gratis, we're going to come along and do it for you anyway for a good landlord, or what do they charge? And the average is £200, £300 to attend. So, when you compare, and our advocate, that's the representation, and they know they can talk to the judge on an aside. They can go into chamber, and that's the difference. So an agent has to be really aware of the cost involved on attending.
I mean, does it? Does it cost any more to get an advocate in compared to an agent charging £200 or £300?
Yes, it does. Yes.
But
Yeah.
I'm assuming you're more likely to get possession, aren't you?
Yes, you are. Yes, because they know, and I always say to a landlord, if you wish to attend. Lots don't, because of the aggravation. There might be something going on. They want a third party just to deal with it. But if they do, then sometimes the question's asked in court that the advocate has not got that information. It could be an obscure question, and the landlord can then reply that, and it saves an adjournment, and that saves time. So yes, it's all about information that relates to the case.
So your advice is get someone who's qualified in this, who specialises in this, not just a normal general practice solicitor, someone who specialises in Section 8 notices and housing law. And if you can, get the landlord, or necessarily, could the letting agent answer the question?
Yes, I can. Yes, yeah. But due to COVID at the present time, they're restricting the numbers in court, so you have either or.
What would you recommend? The landlord? I mean, again, most of the people watching this are going to be letting agents, not landlords. Would you recommend they attend, or would you send the landlord?
I'd say don't. If you don't want to attend, don't attend. Our advocate has it. If we have all the information beforehand and it's all served correctly, and the bundle's correct, then you don't need to attend. It saves time.
And do you think tenants nowadays are getting legal advice, even though, I mean, it's, through legal aid, or they're getting it through, certain charities to put barriers in the way? And what can agents do to mitigate that risk?
Okay, the worst offender, in my opinion, is the council. Even a legal notice, they say it's wrong, and they say go back and check that. It's void. And there's nothing wrong with that. So it's where they take their advice from. If it's somewhere like a charity, then all they're interested in is further in their name. So the advice they give them is don't say anything, shut down, sit tight, don't move out. So, and Google, there's a lot of information on there. There's a lot of good information. Our website carries some good information. A tenant can read that and see, because to be fair, everybody should know the process.
And then just finally on this video, the white paper's out at the moment. We're in late July 22 about the removal of no fault section 21. So now I know that decision hasn't been made, but if you don't mind me asking, if that does get removed, what needs to be put in place to protect landlords?
Okay, a landlord needs their property back for a renovation, for selling, or to move back into. So those three things are the crucial ones, and you need a facility for that to happen. At the present time, they keep saying it's, the name of that is a no-fault eviction. What it actually is you don't have to give a reason at the present time. So under the Section 8, you would have to give a reason, but those three things should be included. And I know that there's a lot of work in the background going on, a lot of lobbying, but until it's out, none of us knows what it's going to include.
Interesting times ahead. Thank you for your time today, Mike.
Yeah. Thank you very much. I really appreciate it, Chris. Thank you.